but a right to liberty, a right to negative liberty, a right to be free of state constraint. Now, the great antithesis to liberty in the English tradition was Edmund Burke in the 18th century. And he had read the French Enlightenment and his predecessor by a century, John Locke, and his horrified reaction was to say, these idiots think there's something called a right to liberty. The French and the English both have this view that you have a general right to be free of state coercion. He says, how could that be? That is a recipe for anarchy. To be generally free of state coercion means the state can't have any criminal law. That's to raise the black flag of anarchy, and Burke said that's impossible. Everyone writing in the liberal tradition has seen what I call the Burkean problem. I see that Berlin raises it on page 2 of the materials. And Berlin gives one of the kind of classic answers. Before, I don't think the problem is hard to see. If negative liberty is what you're talking about, that's freedom from state coercion. You can say why that's good, but the moment you say you have a right to it, and the state has a correlative duty to respect your right, it looks like the state has the duty, not in general, to enact criminal laws or coercive legislation of any kind. That is anarchy. That's the Burkean objection. There's 4 ways in which the libertarian tradition answers that word. The first is the one Berlin himself explores in the middle of the second column on page 2. And that's to say, but the right to liberty does not apply to all actions. It applies only to some actions, and at that a tiny minority of actions, not to most actions. So it's not a general recipe for anarchy. It's when he says, the classic English political philosophers disagreed about how wide the area could or should be, but they supposed that it could not be unlimited, because if it were, he was reading from Berlin, page 2, second column in the middle, because if it were, it would entail a state in which all men could boundlessly interfere with all other men, the Hobbesian state of nature. So it can't be that it applies to all actions. The first and most obvious answer is to do what Berlin suggests, which is define an area of actions, a set of actions, that the state can't touch with its coercive laws. That's what the right to liberty is. The state can coerce murder and rape and so forth, all of those actions with its criminal code, but there's a set of choices or a set of actions chosen that the state can't touch. And the trick is to define that area, and as Berlin says, different people define it differently. Now that's also Mill's strategy in his On Liberty, where he talks about a sphere of liberty. A sphere of actions, as he put it, absolutely immune to state coercion. He defined that in terms of the harm principle, which we'll talk about in a bit. But however you define it, the general form of the answer is negative liberty as a right does not lead to anarchy because it only applies as a right to certain actions but not to most actions. The trick is to say what the sphere is about certain actions. That's answer number 1. Answer number 2 is to say perhaps you can define the sphere of actions immune to state coercion not by a general criterion, the line around a sphere, but rather by discrete rights. The tradition of Western liberals like Ronald Dworkin, John Rawls, and others is to say the sphere of liberty consists of, say, the 32 rights in the American Bill of Rights, or some list of discrete rights: the right to free speech, the right to free exercise of your religion, the right of assembly, the right of free press, the right not to incriminate yourself, the right to be free of a cruel and unusual punishment, or some such list of discrete rights. The right to liberty then becomes an abbreviation for 10, 20, 30, 50 discrete rights, without there being a general criteria of what makes all of those discrete rights immune to state coercion. It's a little unsatisfying because it's lumpy. It doesn't give you a general criteria. It just says here's 52 things the state shouldn't touch. But that's a possible approach that doesn't collapse liberty into anarchy as well. Approach number 2. Approach number 3, as I have it on the outline, although it's going to be the first thing we talk about, is what Randy Barnett, a well-known libertarian in America, whom I excerpted briefly an article from, and many others, like Joel Feinberg, who used to teach philosophy and social philosophy at the University of Arizona until his death, used to call the presumption of liberty. This is a quite different strategy. Liberty doesn't have an area that confines it. Liberty applies to all actions whatsoever. It's not a right. The state doesn't have a correlative duty not to legislate. It's simply a presumption, in some sense of the word presumption. It's presumptively good that the state not coerce you, but it's rebuttable. Namely, when an American criminal code tells you there are 15,000 things you can't do, there's 15,000 rebuttals, presumably, to justify those 15,000 things, saying, well, we can coerce you there because, although it would be good if we didn't, it's better that we do, fill in the blank why it's better. Presumptions don't lead to anarchy because they're rebuttable, unlike rights. The difference between a presumption and a right is the force in the reasoning of those to whom the duties are addressed, namely state actors. So that if it's a presumption, the state can say, yeah, but there's better reasons to overcome the presumption. That's why we have criminal laws against murder, for example. Whereas if it's a right, rights by their nature are very difficult, if not impossible in some conceptions, to overcome by other kinds of moral considerations. So the third answer is not to contract the area that liberty protects, it's to weaken the protection that liberty gives to all actions. That's called the presumption of liberty. 3 ways so far to avoid anarchy. The fourth way is what I call the derived right of liberty. Maybe what you have a right to when you have a right to liberty is not a sphere of actions immune to state legislation. It's rather a right to certain reasons being improper reasons for state legislation, state coercion. So when we talk about the Lochner case, you'll find Justice Peckham from the U.S. Supreme Court mostly getting exercised about the reason that would lead New York to tell bakers why they can't work more than 10 hours a day. It's New York's paternalism, he thinks, telling bakers what's good for them, that so offends him. Mill himself is often interpreted, fairly enough, in his essay on liberty. When he says the great enemy of liberty is paternalism, what he means is the reason for legislation may be more important in your measuring how well it respects liberty than its content in terms of the actions it protects. Maybe liberty protects you from only paternalistically or other badly motivated coercive legislation and not against coercion itself. If that were the case, liberty would also not lead to anarchy. So 4 sorts of answers that we want to explore. Those are the answers to the Burkean problem that organize the materials. If you look at the table of contents, here's how we're going to go. I want to explore in this hour the third answer I gave you, the presumption of liberty. That's what I've got under section 2 on the table of contents, pages 17 to 28. That's answer number 1 to Burke, namely, you weaken the force of the protection you give liberty in order to keep the area covering all actions. Session 3 and 4 have the same materials, but they instantiate 2 different attempts to define liberty in a way that answers the Burkean objection. I thought for the first session tomorrow, we would see what we could do to make out the notion of discrete rights. One way to define the sphere of actions immune to state legislation, the right to liberty, is in terms of a set of discrete rights to, and now fill in the blanks, to use birth control devices in having sex, to have an abortion after you've had sex, who and when and whether to marry, who and how and whether to have sexual intimacy with another person, whether you get to kill yourself, to have others assist you in killing yourself, to allow yourself to die, or even to have others kill you with your consent, active euthanasia, as a set of discrete rights, which is probably the dominant approach of the U.S. Supreme Court in defining liberty in a way that protects it against state regulation by defining 6, 7, 8, 10 discrete rights. That's the third session. The fourth session, the second one tomorrow, we'll use the same materials to see if we can draw out of them the answer that Mill and Berlin and others have sought. What's the general criterion, if we can find one, that defines the sphere of actions in the interstate regulation? Other than these 6 examples we're going to go through, what do they have in common if you find them all plausible that makes it the case that the state shouldn't coerce your decision about whether to have an abortion, for example, or whether or not to die? What is it about that decision that makes it immune to state coercion when the decision to do almost anything else is open to state coercion? That's to try to give the first answer, namely protecting the sphere of liberty by defining it and having a certain order. The last 3 sessions, both on Wednesday and the one on Thursday, then deal with what I call the derived right of liberty. The name comes from the derivation of the right from what's more basic. What's more basic is the duty of legislators to enact coercive legislation for some reasons, but not for others. So if paternalistic motivation, for example, is the enemy of liberty, the way Mill and Justice Peckham think it is, it's the right to be free of paternalistically motivated legislation, whatever its content might have been. That's to aim at the reasons for the legislation, and we want to develop the Millian and then post-Millian taxonomy of possible legislative motives. There's 150 years of development about what motives are proper for legislators who want to take a look at that. That's what we're going to do on Wednesday and Thursday. Everybody got the game plan pretty much down? So 4 answers to Burt. We're going to look at all 4 one at a time. Answer number 1, presumption of liberty. Material starting on page 17. Let's take a look at the presumption of liberty as such. 17. Page 19. That's the decision of the United States Supreme Court in, page 17 in Locker. Can't read my own handwriting. Locker v. United States. Before we get to the decision, let's just spend some time. If you're looking at the outline that was handed out for today, I'm now moving to session 2, and particularly, what is such a presumption before we get to the Lochner case itself. Let's talk a bit about what it would mean to have a presumption in favor of negative liberty. 2 things to clarify about a presumption of liberty. One, what is liberty, and the other is what a presumption is. We've pretty much clarified the notion of liberty. We're talking about negative liberty, negative political liberty, the absence of the state coercing you. What's a presumption as opposed to a right? God, how long ago? 25 years ago, I used to teach evidence law, very briefly. In evidence law, we usually tell our students a presumption does 3 things. Presumption has 3 attributes. 2 of these come from the peculiarities, I think, of an adversarial system of law, or at least one of them does. In an adversary system of law, you've got to put the burden of making a trial work on one party or the other. That's called the burden of producing evidence, usually called the production burden. Someone has to have the burden of producing evidence. So in a civil case, you put on the person who's suing, the plaintiff, the burden of producing evidence that makes out a prima facie case entitling them to damages. You then put on the defendant the burden of producing evidence that shows one of the defenses that would make them not liable for the damage, even if the prima facie case is made out. The same is true in criminal trials. Prosecution has the production burden, the burden of producing evidence, from which a prima facie case of guilt of a certain crime can be inferred by the jury. The defense has the burden, typically, of producing evidence for defenses like self-defense, insanity, and the like, from which an acquittal can come, even if the prima facie case is made out. One of the things presumptions are supposed to do is shift the production burden. So if I make a presumption, here's an old presumption in evidence law. The presumption is, in the days, which are still true, where the U.S. Postal Service is reasonably reliable. If you deposit an envelope with a stamp on it, with an address on it, into the U.S. mail, it is under the United States Evidence Code presumed it was received by the person to whom it was addressed. The mail is regular enough. You don't have to prove someone received a legal notice. It's enough to prove that you put it in the mail addressed to them with a stamp. So there's a presumption. That presumption will shift the production burden onto the recipient, so that if it is proven that you put the letter in the mailbox, the other side now has the burden of producing evidence they didn't receive it. Otherwise, the presumption carries the day. So the first thing presumptions do in evidence law is shift the production burden, shifting the burden of producing evidence from which a fact finder can make a finding. That's the first thing they do. The second thing they do is shift what's more technically called the burden of proof. The burden of proof is usually called in evidence law the risk of non-persuasion. Namely, if you're an equipoise, you've heard the plaintiff's case, you've heard the defendant's case, and you really can't decide. I don't know any legal system that dispenses Solomonic justice. Namely, a justice that says, if I can't decide, I just split the baby. You need default rules. A burden of proof is a default rule. If you can't decide one way or the other, now the burden of proof doesn't work. Then you are to decide for whoever doesn't have the burden of proof. That's why it's called the risk of non-persuasion. If you have the burden of proof, you take the risk you don't persuade somebody. So that if any fact finder ends up in equipoise, then whoever has the burden of proof loses. Whoever doesn't have it doesn't have that risk of non-persuasion, and they win, even though the fact finder doesn't necessarily believe them, they just can't decide. So the burden of proof is called the risk of non-persuasion, quite different than the burden of producing evidence. Burden of producing evidence is procedural. It's what you have to do to make a trial work. The burden of proof is epistemic. It has to do with what you can know, or what it is you're supposed to infer if you don't know. Socrates gives this example. He said, I am wiser than anyone I know. How come? Because I know what I don't know and they don't. Namely, I know of my own ignorance, and there's a default rule about knowledge. This is what burden of proof is. I don't know, and now I know because the default rule tells me what I know. Namely, the default rule says, in equipoise of disbelief, believe that person, the one who doesn't have the burden of proof. So two things so far. Presumptions shift the burden of production from one party to another. Presumptions shift the burden of proof from one party to another. And usually they do both in Anglo-American evidence law. Presumptions are said to do a third thing. Namely, they stay in as evidence of the truth of the matter presumed. So that I produce evidence that I put a stamped, pre-addressed envelope in the U.S. mail. The presumption is it was received. That puts a production burden on the other side to produce evidence it wasn't received. That also typically puts the burden of proof on the other side. If you can't decide whether it was received or not, you are to presume it was received because the burden of proof is shifted to the person who claims non-receipt. But it also stays in during the fact-finding process as circumstantial evidence. Namely, presumption states a rule of circumstantial evidence. It is most likely the case a deposited letter was received by the one to whom it was addressed. It stays in as circumstantial evidence against their saying, for example, I never got it. And the fact finder is entitled to take the circumstantial evidence into account and weigh it against, say, the evidence of someone saying I didn't receive the letter. So it has an evidentiary function as well. Now that's pretty standard American evidence law. Prima facie, what's the presumption of liberty like? The presumption of liberty, as Barnett and others, myself, Feinberg, describe it, certainly has the first of those three functions. It thrusts upon the state the burden of producing evidence why this law is a good idea. This law is coercive. It therefore takes away negative liberty. The presumption of liberty says, therefore, the burden is on the state to produce evidence of a good reason for taking away citizens' liberty. So it's certainly the first of the three. It certainly shifts the burden of producing some kind of reasons why the state would be justified in coercing certain behavior. It shifts the production burden on virtually any idea of presumption. It has the third function as well. It stays in as evidence of the truth of the matter presumed, namely, since negative liberty is either instrumentally or intrinsically good, it's always a weight when you're weighing up whether legislation is justified that you're taking away liberty. There's going to be lots of other reasons why certain laws are really bad ideas. There are going to be some reasons why they're good ideas. When you're weighing whether it's a good or a bad idea, the presumption of liberty stays in as a weight, saying it's always against legislation that it takes away citizens' negative liberty. That always counts as a bad. There's got to be more good over here to justify it. So it has the third function as well. I don't think it has the second function. I don't think there's a risk of non-persuasion. I can imagine someone saying, the burden of proof is always on the state. So if you can't decide as a reviewing court whether this legislation is taking away too much liberty or not, you're to presume against the state. There are presumptions like that. The rule of lenity in criminal law is supposed to be like that. If a criminal law is unclear and you can't decide whether it applies or not, you're supposed to presume it doesn't apply, that is, you presume against the state. You could have a burden of proof or a risk of non-persuasion of that kind, but typically people don't think that about a presumption of liberty. So the presumption of liberty presumes, in the sense of shifts the burden on the state of producing reasons why legislation is justified, and it counts against any of the reasons they produce that the legislation is justified. It stays in both senses. Next question, can we quantify the strength of the presumption? How much does it count that it takes away negative liberty? Procedurally, under evidence law, we actually have kind of rigid categories, which I put down in the outline here under Arabic 3, under 1b of my discussion. We actually have a quantified mode, my signature, about strengths of presumptions. Sometimes it is said presumptions are not underlain by any kind of rule of circumstantial evidence. They have no weight when you're balancing up whether something is true or not. Sometimes it is said they have some weight, by which you mean it is enough weight, if it's a jury system, to get to the jury on the issue. Sometimes they mean it has so much weight, it not only gets to the jury, but the jury has to find in your favor unless the other side rebuts it with rebutting evidence. And sometimes it means it has conclusive weight. We have 4 gradations of weight in adversary systems. If those don't make any sense to you, forget them, because I don't think there's any analog for the degrees of weight of a presumption of liberty. There isn't any easy way to quantify how it is, how much weight it is that you give liberty when you're balancing legislation. The U.S. Supreme Court has something of a lumpy function, but it's not lumpy in this way. Here's how I want to approach the strength of the presumption of liberty. It's Arabic 4 on this outline. I want to do old American constitutional law, the Lochner case, which is the most famous exemplar of this approach to liberty. Not just because it's American, but because I think it approaches liberty in a distinctive way. Secondly, I want to contrast that with what, since the New Deal, has been present in American constitutional law with the Williamson case, which is usually in most constitutional law texts the classic case used to illustrate the present approach. And then I want to ask Randy Barnett's question in the article on pages 24 to 28, which of those is right? Which is the right weight to give to the presumption of liberty if that's what we're doing, is presuming liberty? The old approach, the new approach, or something else. So, let's see how it goes. Let's look at the Lochner case, starting on page 17. Famous old case, mostly famous because of its repudiation in the New Deal in American constitutional law, at least because of its repudiation later on. Look at the issue in Lochner. The issue was about bakers in the state of New York on page 17. New York had passed an hours restriction about how much bakers could work. And it said by statute, you couldn't contract to work, and you couldn't work for more than 10 hours a day or 60 hours a week, which is actually a lot. But nonetheless, 60-hour work weeks, Monday through Saturday, 10 hours a day, the maximum that could be done. The question was whether that was consistent with liberty, and I subdivided that into three things that at least you could argue was liberty that was at issue. One, and the most obvious, is it interferes with the liberty of bakers, individual employee bakers, to work more than 10 hours. Peckham mentions that. They get overtime pay. That they don't get by New York statute. They can't work more than 10 hours even if they want the money. But symmetrically, of course, it takes away the liberty of employers to employ people for more than 10 hours as well, paying them whatever they pay them, but nonetheless, it takes away their liberty. And thirdly, emphasized by the court, is it takes away the ability of both employee bakers and employer bakery owners to contract to have someone work more than 10 hours a day, 60 hours a week. And somehow the inability to contract seems to be a special liberty the court wants to protect. So we have three liberties at issue, although all tightly related. They all have to do with hours of work. One side of the balance is to figure out what weight we should attach to this liberty. Now there's two possibilities. One would be, you could say, the presumption of liberty presumes equally of all actions they should be free of state coercion. And it's of equal worth, whatever act you want to do. So if you want to bake bread for more than 10 hours, that's a liberty. If you want to kill people for fun, 6 hours a day, that's a liberty. If you want to simply drink beer and smoke pot all day, that's another liberty. But all liberties are equal in the sense that their coercion by the state is equally bad. That would be one possibility. The other possibility would be to say, but some liberties are more important than others. The liberty to work is a pretty good liberty. The liberty to sit around, drink beer, and dissipate yourself, although it's a liberty, isn't as important. And the liberty to go kill people for fun, although that is a liberty, it's not of much value. That liberty is on a kind of scale of degree of importance. And the presumption of liberty doesn't have a fixed weight. It has a weight proportional to the liberty of the action involved. Let's just start there for a moment. Between those two views, are all liberties of equal value, that is, a liberty to do any action is of equal value in the sense that the state shouldn't coerce it, presumptively, or does the presumption gain weight by the kind of action that you want to do? If you want to write great poetry, that has heavy liberty. If you want to write crappy comic books, that has lesser liberty. Is liberty a curved thing or a flat line if we're graphing its importance? Notice we're only on one half of the balance. One is what's the importance of liberty. The other is what's the reason for state coercion that we're going to balance against it to see whether this legislation is justified. So we're doing one half of the balance. The question is, how do you picture that balance? On this half, is it a fixed amount, or does it vary by the action involved? You got an intuition about that? I've got a seating chart. His first name's democracy. And I have made some choices about what to talk about. I don't usually present things historically, but I do think the ideas, of course, have a historical background, and you can see where this one comes from. This is Locke, Mill, Isaiah Berlin, and the like. A Western tradition. I don't think you can take all accounts, all traditions into account and end up with anything discrete to talk about. If I have to talk about Der Geist der Deutsche Volk for Hegel, we're going to be doing something very different than we're doing here. I think you have to pick something that you think is discrete and plausibly valuable to then have a subject. Now, I don't know that you need to know the history of how it came to be. I do teach my American constitutional law students that these ideas we are studying are paid for in blood. That these are not simply abstract ideas, they are what sent Americans to the barricades in 1776 and in 1861. There is a history, but I think philosophers are more interested in the shape of the ideas as history has developed them than how they got shaped by the history. Quite possible to do it the other way. Quite possible to be more interested in the historical development than in the end product. But I think, like most philosophers, are more interested in the end product than in the intellectual history that brought it to us. The payoff is whether or not there's a discrete notion of liberty that's worth talking about. As you started out saying, it's not definitional. It's not. It's rather to pick out something that exists as a discrete value, focus on it, and see how it impacts on the limitation of law. That's my topic. So I make no apologies for not dealing with all traditions. I don't think you can. And I also make no philosophical apologies for not doing history because unlike 2,000 years of philosophy, we often don't. Recognizing those are perfectly good enterprises to do as well. But my question was actually much more discreet. My question was with respect to the weight of liberty. Should we conceive of that weight as varying by the action we do, or as being a constant? Every action is protected by the presumption of liberty. That's the general nature of the presumption. The question is, are some actions deserving of more protection, i.e. is coercion of them worse than others? Yeah.
I think that you can speak about some scales of different liberties. The one action is much more important to be protected by law, and the other is not. My point of view that every liberty must be protected in the same way.
Every action?
Every kind of liberty. But what should we think the liberty is? Is it the right to go and kill somebody? Is it a right at all? And is it a liberty? I think that perhaps this notion you were speaking about, that the liberty in general sense is a liberty to do some actions that are prescribed by law. Because if the law writes that a man has a right to 1, 2, 3, 4, 5, then our liberty is to choose among those rights. So it is a liberty because if the law prescribes those rights, it means that all people in this country, they agree that they have just those rights that are written, prescribed by law. So the liberty to all those rights is probably should be the same. So the person can realize each right prescribed by law, and the others probably it's not a liberty at all to go kill or do some actions like those.
Well, that's interesting. So you still have a line that you're drawing, which is there's equal liberty to move your finger, leave the room, speak or not speak. Those are all of equal liberty, but it's no liberty at all, no value at all to kill your neighbor. Isn't it?
Yeah, I think.
Isn't it? No liberty at all to kill your neighbor, right?
Yes. It's
No.
an action, but it's not a liberty, I think.
Sure. Because some actions then, you say, aren't protected by the presumption of liberty.
Yes, it shouldn't be.
And which are those? The ones that law prohibits, or the ones that are morally wrong, or something else?
Oh, in the ideal society, yeah, morally wrong actions should be prohibited by law.
That's right, but some aren't. So we have two different things. One could be it is prohibited by law, and the other is it's morally wrong. Do you think there's no liberty protection if it's a morally wrong action, or only if it's a legally prohibited action?
It's a question, are they the same actions?
I'm telling you, this society, they're not.
Are they not?
Let's suppose they're not. They don't have to be. I don't know of any society that criminalizes all immoral behavior.
Well, I think at least those which are prohibited by law. Because speaking about those which are unmoral, it's very difficult because everyone has different point of view on those.
But now notice how tricky this gets, because we want to use the notion of liberty to limit law. The presumption of liberty says it's bad to coerce people by law into certain behaviors. But if actions lose the protection of the presumption of liberty by being prohibited by law, then the presumption can't limit law.
The presumption can't?
If liberty only protects actions not prohibited by law, then we can't use liberty to limit law, because if law has prohibited something, liberty has no protection on this supposition. There's a circle. So if you're going to say, my choice to kill somebody is not deserving of any protection of liberty, it must be because it's immoral, not because it's illegal, that makes it lose liberty. Because if it's illegality that makes it lose liberty, then liberty doesn't limit the law. It becomes circular. So it must be that it's immoral. Now, Randy Barnett, in his article, at the end, I think it's page 27, says that there's no right to do the morally wrong thing. Liberty doesn't protect immoral behaviors like killing. That sounds more plausible. You could say, well, your freedom begins where your moral duty ends, would be this slogan. Is that right? Could you have the following view about abortion? Two views. One, it's morally wrong for a woman to abort her fetus. Suppose you think that. Two, but she has the liberty right to abort her fetus, i.e. that she has the moral right to do the morally wrong thing. Is that an intelligible view of liberty? Because if it is, then notice this Barnett suggestion that your liberty ends where your moral duty begins isn't right either. Not only is liberty not limited by what's legally prohibited, it's not limited by what's morally prohibited either. Your liberty may be the liberty to do the wrong thing. In fact, notice in that discussion that he's having, Randy Barnett in his article, let's turn to that page right around, it's page 27. In the discussion that he's having of that article, he notes that you might, this is on page 25, and he's raising the example of the medical use of marijuana. Somebody wants to use marijuana, they say that's my liberty right to use marijuana, and incidentally, I've got a good reason to use it. I don't want to just get high. It helps me medically. In the footnote on that page, number 2, footnote 2 on that page, page 25 of the materials, the Ninth Circuit Court of Appeals, in this case, told the woman that indeed she could have a defense of necessity if she were ever criminally prosecuted for the medical use of marijuana, because although the state could prohibit it, she could show she had a good reason for its use, namely she needed it medically. Would that be protection of her liberty? Namely, she can't be prosecuted because she has a good reason. Why not? Liberty needs more than that. Liberty needs to protect your choice when you don't have a good reason. Liberty has to protect you in deciding wrongly, not just deciding rightly. Getting it right will be its own defense, called necessity. Liberty protects you when you do it badly. That's why it's worth something. Liberty cannot end where your legal prohibitions or your moral prohibitions begin. It's stronger than that. It's more important than that. Sorry, I cut you off. Yeah.
But it's not always like that, because sometimes we have liberty only when we have good reasons. It's not always the case when you have liberty with doesn't matter any motives you share. Sometimes there are cases when you have liberty only when you have good reasons, and that's the case. Is that what
that sounds possible? You got an example in mind?
To kill a person, not a person. For example, you defend yourself or your family. Do you have the freedom to kill another person who is trying to kill you or your family? Do you have freedom?
But it's an exception, and these exceptions could be prescribed by law either. So anyway, if in those exceptions your liberty is protected, you also act in the limits of law. Don't you? Well, that's my idea.
Well, are you going back to the if something's legally prohibited, you can't be at liberty to do it?
I mean that there are some, these examples you're showing, those are rather exceptions. When it seems that the person has no right to do something and that it's prohibited by law, but sometimes we should protect this person. This is exception. And such exceptions are also prescribed by law sometimes, and
they are.
most times they should be.
Okay, look, we've got a room full of lawyers here. We need to get away from the law. We need to get behind the law. We need to have a criterion for judging law. That's what political philosophy is supposed to do. I'm also a lawyer, but not today. So we need to say, I understand there's laws against murder, there's exceptions for self-defense, that's all in the criminal code. But if we're trying to assess whether that's a good or a bad law, do we take into account the deprivation of liberty all legal prohibition brings with us as we weigh up whether it's good to have a law against murder, whether it's good to have an exception to the law against murder called self-defense? Do we have as a criterion of what makes that good law the deprivation of liberty as an inherent bad? Now, we started out with the intuition that you share, I think, with Randy Barnett, which is freedom to murder is not freedom worth anything, so it doesn't count against the law that it coerces you out of killing people you don't like. That's the intuition, right? And the trick is to give shape to that doesn't collapse our enterprise. First stab at giving it shape was that liberty doesn't count because it's legally prohibited. But that just bankrupts the enterprise. Then liberty doesn't become a check on law, it becomes dependent on what the law provides. So we can't do that. Second possibility was maybe liberty is only protective of actions that are not morally wrong. But my abortion example was trying to suggest we need a right to do wrong to be part of our notion of liberty, so that liberty shouldn't end where our obligations begin. Look, it wouldn't be a disaster to think that there is something bad about all coercive legislation, even legislation that coerces you out of killing people for fun. It's just there's also something really good about it. Namely, it prevents killings for fun, which are rights violations, and it also allows you to punish on retributive justice grounds people who do those bad things. Those are two really good things, one preventative, one punitive. They can easily outweigh the bad of coercing people out of one thing they'd like to do, killing for fun. So it's not something you have to win on to justify our criminal code, to say there's no value in liberty with regard to morally bad actions. It doesn't answer the question I started with, though, which is, are some actions more valuable to be preserved from state coercion than others? Kind of a sturdy intuition that some things are worth more to be done by yourself than others, but very hard to give an expression to. You can think of examples. It's more important that the state not coerce you how to write a novel than that the state not coerce you how to build a sidewalk. You may think some loss of liberty is involved in either form of coercion, but that somehow one is more important than the other. But that's tricky to articulate. The simple version is to say all state coercion is bad, and it's equally bad, it's just all the work is on the other side of the balance, namely how much good is being done by a particular coercive piece of legislation. Let's try working on the other side of the balance. What kinds of reasons can justify state coercion? Now take the decision in the Lochner case. The decision proceeds, starting on page 17, with looking at the reasons given by the state of New York to do something which is prima facie bad, given the presumption of liberty. It is prima facie bad to coerce bakers and those who employ them not to have the freedom to contract to work more than 10 hours a week. That's a bad thing. What's the good thing New York is saying justifies the legislation? Peckham seems to have 3 or maybe 4 reasons in mind. Let's see what we think of it. Bottom of 17, second column. He says the question in that last paragraph is whether this act is valid as a labor law pure and simple. Now, if it's a labor law pure and simple, he thinks this is easy. That's a bad reason, and the statute is unconstitutional. The trick is to figure out what he means by a labor law. What does he mean, a labor law pure and simple? He says in the sentences that follow, there is no reasonable grounds for interfering with the liberty of the person or the right of free contract by determining the hours of labor in the occupation of a baker. Okay, why not, you say? There is no contention, next sentence, that bakers as a class are not equal in intelligence and capacity to men in other trades or manual occupations, or that they are not able to assert their rights and care for themselves without the protecting arm of the state. They are in no sense wards of the state. Viewed in light of a purely labor law, namely viewing them as wards of the state, he thinks is an unjustified deprivation of liberty. How would you put in your own words what he thinks the reason of the New York legislature is, if it's judging this to be a justified law in light of this reason? What's the reason? A pure labor law is what kind of a reason? It's a lousy label, but people often are best at labeling their own ideas.
Is it policy options?
No, it's that, but why? What's the reason for exercising the policy this way rather than another?
Well, to protect the rights of the employers against the employers, because there are a large experience of exploiting, and we need to protect their rights. Exploiting the employers. Because the positions are not the same. The one side is strong of an employer, and the employers are the weak side of that relation. So we need to protect the weak side. That's why we restrict the hours of working day, for example.
So, before labor unions, which is is what this case is set in. There's unequal bargaining power between employers and employees, and the bargains that are struck will be unfair bargains. They're not in the best interest of the weaker side. So he's putting in the mouth of the New York legislature the idea that workers need protection from what they themselves agree to, because they don't have the power to agree to what they ought to or perhaps even want to agree to. That's where the wards of the state language comes in. Workers need the state to step in like a parent and be paternalistic. They need to remake the deal for the workers because the workers can't make the deal for themselves. That's what Justice Packer attributes to the New York legislature as one possible reason for its legislation. In the minds of the legislators, he thinks, is the following thought. Workers can't take care of themselves because of unequal bargaining positions, because they're ill-educated, they're stupid, whatever. They need the state to make a better bargain for them than they can make for themselves. And so they'll make it by coercive legislation rather than allowing the workers to contract on their own. Workers won't make a decent bargain. In a subsequent case, close to this one, the U.S. Supreme Court had not said the same for women workers. It rather had the view, in a case called Mueller versus Oregon, that the state could limit the number of hours women work because women aren't men on that 100-year-old view. They can't protect themselves. You need to be paternalistic, or if you like, maternalistic, as a state with regard to women. But you can see Peckham's view. It thinks the New York legislature is being paternalistic. He thinks that reason, if that's what motivates New York, is a bad reason. He, like Mill, thinks paternalistic reasons are the first enemy of liberty. That the moment a state tells its citizens who aren't under any obvious incapacity, we know what's better for you and we'll make the deal you didn't make for yourself, he thinks that's inherently an illicit reason to coerce the freedom of decision. What do you think?
It's a controversial position.
Of course, that all rest of the things are.
Could be also an instrument to protect freedom, for example. It's the same thing. It's also the issue about the offer or threat.
Mm-hmm.
They can offer you to work extra time, but you don't have abilities to say no. So it could be that position. I don't know the situation there, but it could be that situation. And sometimes they just don't have abilities to go across the position of employers. So the paternalist policy could be the measure or the instruments of protection of liberty, I think.
Well, you could.
Not always, but it could be.
There's two questions. One is Peckham right that paternalistic legislation for classes of competent citizens is basically an insult to liberty? That's one thing. The other is he right in applying that here? Are workers a class of people who need paternalistic state legislation? Two different questions, right? One is one about the nature of the reason, the other is does it fairly apply here? Yeah.
Yeah, I think in this regard, he suggests that this paternalism infringes upon economic liberty. If we look at the Lochner era as a whole, the judges there were for economic liberty, for the ability of parties, of employers and employees to have a freedom of contract. So in this case, we see the strong desire, like the underlying foundation being the strong protection for economic liberty, that whatever you contract is your decision, that the government should stay out of it. However, like turning to your second question, I think whether it's good or bad, I think it depends on the concrete situation, and I think it also depends on the year. Like we see that the year of this decision is 1905, when perhaps much more focus was given upon economic liberties, economic freedom. Now, like another question is, what if this was a case that was before a judge today, in the 21st century, when much more focus is given to issues like health, perhaps to like issues like labor rights, right, and other issues. So I guess perhaps in today's world there would have been another decision.
But that's social science. I want to know what you think. So let's make it today, and let's do what Peckham does. He's anticipated you. Let's not talk about bakers. Let's talk about lawyers. And in America, I think it's true lawyers work too hard.
Well, my personal...
So suppose New York says to its lawyers, it's his example, you guys work too hard. We're going to limit lawyers to 10 hours a day, 60 hours a week. After that, you're done. You got to go home. You cannot stay down at the office. It's bad for you to work that hard. Your divorce rate is up, your eyesight goes to hell, your sex life is terrible. It is bad for you to work this hard, and we're going to redo it today. What do you think? Good law?
Well, if you're asking about my personal opinion, is that it's good law. Because I believe that when it comes to legal work, you've got to be careful. And what we see in those big law firms is that you work like 24 hours sometimes a day, and then a mistake that you make today, like because you didn't sleep that night or because you overworked in general, can cost your client perhaps billions of dollars. So why risk? Like, I personally don't understand this problem of overwork.
Good. Now that's the argument that Peckham uses about bad bread. He says a third reason, we'll skip over the second, a third reason that might justify regulating the hours of bakers is that tired bakers make bad bread. They don't wash their hands enough, they're not clean, and they make bad bread. You argue that tired lawyers, like tired doctors, make too many mistakes. That's a different sort of reason. Notice that's not paternalistic at all. That's to protect consumers of bread, of medical services, and of lawyers from bad lawyering and bad bread making. Let's put that aside. Suppose that's not the case. Suppose lawyers actually have the capacity, and some of my friends seem to work 60-hour work weeks, 100-hour work weeks, and they do superb law. But they lead lousy lives.
They have freedom to choice, lawyers. But bakers, they don't have. In conditions where unemployment is very high, okay? You have to accept the conditions of employment. But he says that you have to work 70 hours. For example, my father had a shop. When he hired workers there, as a clerk, he required them to work 10 hours in Bahrain, in my country. And he will not accept any employers who is going to work there like 8 hours. In such a situation where unemployment is very high. So if we say that there is no liberty without equality, and employer is not at the same stance, the different stance.
Right.
So we have to provide equality.
Now look, there's another reason. That's not one used here, but you can see it as a reason. If there's actually not enough work for bakers, or not enough work for lawyers, heaven forbid, you're going to have to divide it up by having a quota system that will limit their hours. That would be a possible reason. But notice, if we're dealing with the reasons of the New York legislature, we need to put aside those others as possible reasons. We're trying to focus on just one kind of reason. You get perfectly good bread and perfectly good law. There's enough to go around. You don't need to limit it for that reason. The only reason, let's assume, is you think working that hard as a baker or as a lawyer makes you lead a less good life. And I'm sorry that you don't see that, so the state's going to tell you. You cannot bake bread for more than a certain number of hours, and you cannot practice law for a certain number of hours. Is that justifiable? For that reason. That will get us to Peckham's reason without all the other possible reasons being out there. The quota system is quite possible in a case in which there's only so much work to go around. You may have to divide it up.
I think this is a rather challenging question, and it depends on the personal preferences. Because for some, doing all the work related to like baking something, bread, might be a love of all of his life. So he would rather do something at work rather than like going back home and like playing with his kids. So maybe for him, it's better to like for a lawyer to do legal work, and that's his life. And if you deprive him of that, then that's encroachment on his personal liberty to do what he wants. Because there are different types of people. There are people who like overworking, and there are those who like a balanced life.
So should the state try to pick out the ones for whom it's good and the ones for whom it's not good to work so hard?
No, I think when it comes to such subjective issues like this is good for you or this is bad for you, then a state cannot really interfere too much. There is a certain line which the state shouldn't.
Let me put your point more strongly, because you're almost with Justice Peck on that. A state shouldn't interfere at all for that reason, he would say. There are lots of other good reasons. We'll talk about those, but if this is the only reason,
Right.
the only reason is because you think lawyers lead lousy lives if they work too hard, that's not a good reason to justify the legislation. We recognize that they could well be right, the legislator. Could well be right. Many lawyers would do better if they went home and played with their kids. But you're also right, there may be some lawyers for whom actually their kids are nasty little creatures, terribly raised, spoiled brats, and they're much happier if they stay down at the office. They stay there for a reason. And the law won't pick them out. The law should stay away, Peckham says, it's the only judgment it had, the only reason it has to pass this limitation is it thinks it knows better than the lawyers or the bakers what's good for them. That's not the state's business, he would say. As a matter of liberty, that's a bad reason. I saw some hands over here. Yeah.
Well, in some way, I see that those prescribing a maximum working day like a protecting of rights and protecting of liberty, perhaps. Because why do we have this maximum time of a working day? It's, as to me, it seems like to avoid some exploiting of people. Because if we have some maximum 8 hours working day, we know that we have a minimum payment for this time. So if you are a baker and it's not enough for you, you can go home and you can find some neighbor and bake pizza bread and get some more money if you want. But you have to know that this maximum 8 hours gives you some minimum payment and you can live on this money. So in this way, it is protecting of your freedom, of your rights.
Perfect. And the reason that I think it's perfect is because it raises the second of the 2 points I distinguished. The first point we were discussing is whether paternalistic reasons are in general good reasons, and Peckham wants to say not at all. But of course, for certain classes of citizens, paternalistic reasons are good reasons. Which class is that? The ones who really can't take care of themselves. A just state does not let kids play in open sewers. A just state protects people who don't have the capacities to protect themselves. And if workers without labor unions are of this kind, then you might say, Peckham, you're right about paternalism generally, but you're wrong about how it's applied to workers. Pre-labor union, workers need help. Now, that's why I raise lawyers. Lawyers don't have labor unions. Do you think lawyers need help in bargaining about their hours?
They have freedom to choose. They work for themselves, lawyers. You don't need to protect them.
We don't need to protect them, right? It is an interesting market failure in American law today. Why lawyers work more hours than I think most of them want to work. One of my law students at the University of California, Berkeley, was going to start an alternative practice for lawyers who wanted to not work more than 60 hours a week. And it was a non-partnership track, and it did piecework, but you got to go home. You got a guaranteed time at which you got to go home. And she said, look, the doctors have that. It's called emergency room practice. You're not subject to odd hours. You can limit your hours, you limit your pay, and you limit your professional advancement, no question. But it may be worth to you that. Why is it the case that America doesn't have it? I noticed just this year she's finally succeeded. Now many major law firms are offering non-partnership permanent associate tracks with guaranteed hours, lower pay, and no chance of partnership. So that it's possible lawyers are getting what many of them wanted, but I don't think anyone ever had the intuition that the lawyers of America needed paternalistic state legislation protecting them against their own bad judgment and working too hard. I think with Justice Peckham they would have risen as one and said that's a bad reason as applied to a class that does not need paternalistic legislation. Paternalism insults anyone to whom it's applied. It's for the idiots and the ineffective and the people who actually have some kind of incapacity, which could be economic, no insult to themselves. But not for people that are in full possession of their faculties and have every capacity available to them. Peckham echoes Mill, I'm thinking that's just an insult to a free citizen to tell them, we can tell you what's better for you, for that reason alone. Now there are other reasons, and one of them is bad bread. One of them is the health of the worker. That it makes you unhealthy, he thinks might be a reason. But notice that's paternalistic too. The worker doesn't judge his or her own health, so the state has to judge for them what's healthy with regard to working would be itself paternalistic interference. Anyway, one thing the presumption of liberty could be measured by is if you look at one side, how much weight do you give to the action that wants to be done by the individual in terms of its protection by liberty? How bad is it to coerce that kind of choice? Maybe that's a fixed sum, maybe it's variable. On the other side is what's the reason the state's giving for the coercion? The presumption of liberty analysis invites a balance. Balance against the bad of coercing this kind of choice, the good that is being achieved. Some things that are thought to be good aren't really very good if they're like paternalistic reasons. They're judgments, for example, about what's good for a person. Anyway, that's the way it's supposed to work. Notice I say this is the old American approach. Quite right, this is a 1905 opinion. This is when the presumption of liberty had real weight in American constitutional law. It overturned on grounds of liberty quite a bit of legislation. What I want to start with, I guess it's going to be tomorrow since it's 1 o'clock. What I want to start with tomorrow is the next case, the Williamson case, 1955, which represents the current approach to the presumption of liberty. That deals with eyeglasses in Oklahoma and what sorts of liberties involved and what sort of reasons are given. So why don't we start there tomorrow on the Williamson case. We'll talk some more about the presumption of liberty, and then I want to get started on that troublesome notion of not a presumption, but a basic right to liberty. The state can't do it, even for good reason, because it's your right to do certain sorts of things. So why don't we adjourn for tomorrow?